friends, I hope you all are doing extremely good. So in today's session, let's talk about revocation of patents. So whenever we talk about revocation of patents, this has been talked about in section 64 of the Act. So first and foremost, you need to understand that the grant of the patent does not warrant the validity of a patent. So a patent can always be revoked, or it can always be cancelled by on a petition before the High Court or any of the authorities which is being provided by the Act, and during the lifetime of that patent, it can always come into the public domain. So at present, what section 64 provides is that only the High Court has the authority to revoke a granted patent. So who can file for the revocation? It's either any person interested. So the definition of any person interested is under section 21T, who is being affected basically by the trade of that particular, or who is indirectly or directly being affected by the trade of a particular patent, a grant of a particular patent. So that person is a person interested. The second category who can file for the revocation is the government, and the third category who can file for the revocation is by means of a counter suit in a suit for infringement. So infringement proceedings can lie before either the district court or the High Court. It's the commercial courts or district court or High Court. So but whenever there is a counter suit to the infringement, so what counter suit actually means is that for example, A is infringing the patent of B, and B has filed a suit for infringement. Let's say it's filed before the district court. So A can always file a counter suit to that infringement proceeding, stating that B's patent is not valid, and if a counter suit is being filed, so all the proceedings get transferred to the High Court, because only High Court has the power to revoke the patent as of now. So there are certain grounds in section 64 based on which you can claim the revocation. The first and foremost ground is that the claimed invention is claimed in any of the claim of an earlier priority. So for example, there's a non-patent literature which has an earlier priority, or it has been into the public domain prior to what your current patent is. So in that case, that becomes one of the ground of the revocation of the patent. The second ground is that the patent was granted to ineligible person. Remember that there are certain category of people who can file for the patent, that is in section 6. So section 6 of the Act tells about that who all can file for the patent, that is the true and the first inventor, or assignee of the true and the first inventor, or the legal representative of the deceased of the true and first inventor, or the assignee of the true and the first inventor. So if the patent has been granted to someone who is not eligible for that particular patent, then it can be revoked. Or it has been obtained wrongfully. If the patent has been obtained wrongfully in contravention to the rights of the person, then also it can be revoked. If it is not an invention, remember that there are certain conditions for an invention to be called as invention. So if it is not there, 21J, section 21J talks about what is an invention. So if the conditions of section 21J are not fulfilled, then it again gets revoked. Lacks in novelty, that is, it is not new. Or obviousness, no inventive steps, section 21JA. If it lacks section 21JA, then again it's a ground for revocation. Or invention is not useful, lacks industrial applicability, section 21AC. Or does not sufficiently and clearly define invention and method it needs to be performed. So best mode is not defined. If the best mode is not defined, then again it's not an invention, but best method has to be defined, section 10. or the scope is not clear. So if you have a very broad claims, then again it would not be a patentable invention, and it can go for a revocation. Patent was obtained on false representations. Our subject is not patentable, so does not fulfill the patentability criteria. Secretly used before the priority, or failed to disclose information under Section 8. Section 8 is the Form 3, and it talks about the undertaking for foreign filings. So if you have failed to provide those undertakings regarding foreign filings, or if you have misrepresented by not disclosing what your foreign applications are going through, or what is the stage of the foreign applications, then it becomes one of the grounds for revocation. Or it's contravening the directions under Section 35 and 39. These are the secrecy directions for the patents which are related to the defense of the nation, or Section 39 talks about the foreign filing license. So as per Section 39, if you are an Indian inventor or Indian applicant and wishes to directly file into the foreign jurisdiction without first filing over here in India, then you'll have to seek a direction from the patent office under Section 39, that is known as foreign filing license. We'll be talking about this foreign filing license in detail. It's a very short topic, and we'll be talking about it. So if you have contravened the provisions of Section 39 or Section 35, then again it becomes the ground for revocation. Leave to amend was obtained by fraud. So if you have amended a patent and because before amending the patent you need to seek leave from the controller, and if that leave has been leave means permission over here, so if that permission has been obtained through fraud, then again it becomes one of the grounds for revocation. Or CS, that means complete specification, it wrongly mentions or does not disclose the source of biological material, that is National Biodiversity Act. So, and as per that act, if you are using any of the biological material in your patent, then you need to disclose the source of that biological material into the patent. So if you have disclosed it wrongfully, or if you have suppressed certain information, then that becomes the ground for revocation of patent. Or anticipation because of traditional knowledge. So traditional knowledges are not patentable. So if you have applied for a patent, that patent has been granted, but later on it is found that that particular patent is based on a traditional knowledge, then it is again a ground for revocation. I hope you all liked this video. If you have any doubt, you can always drop them in the comment section below. Please do hit the like button and subscribe my channel. Thank you.